So how soon can you come up with $1,000 restitution, Mr. Johnson? No, I'm not giving you the end of the year.
Well, I was trying to follow the motion.
Okay, no, back up. You just said you wanted to file a motion. And I asked you, why didn't you file the motion? What stopped you from filing the motion you want to file? I've got a file now so we can actually discuss this.
Okay, Ms. Osmond, or Ms. Knapp is the attorney of record.
Okay?
The motion, regarding this, I have not seen it.
I don't think there was a formal motion, was there, Mr. Marler?
Where it was mentioned that there's been a probation violation, so there's a hearing scheduled for today. Are we on the record?
Yeah, we're on the record. Let's get your appearances on the William Johnson file.
Good morning, Your Honor. Mohammed from the Mastiff.
Peter Verona, P7843, and I the counsel for Mr. Johnson.
Thank you.
Your Honor, it's my understanding that the defendant has failed to pay the $1,000 restitution amount that was ordered by Your Honor. As you know, Your Honor, on March 18th, an order was generated, probation,
Right.
and it required the defendant to pay $1,000 in restitution within 60 days. It's now over 120 days.
Right.
Failed to pay that amount. It's my understanding, based off what's been brought to my attention,
You guys can sit down.
that the defendant has no intention on paying that $1,000. If there's one thing I've learned from this court, it's that the court speaks through its orders. The defendant failed to comply with the court's order. Additionally, at the last hearing, which I was not a part of, it was brought to my attention that the defendant had
I'm sorry. When you say the last hearing, you're talking about the March hearing?
June 25th, I believe.
Okay.
It was brought to my attention that the defendant had made comments to the victim despite the court's no contact order. It included profanity. It was brought to the attention of a court officer where he responded to the interaction. So the comment that's being displayed by the defendant is a complete disregard for the court. Additionally, I was also advised that there was a PPO for this specific defendant by the victim in this case at the time that he had made those comments to her. Again, it was using profanity against her. I believe the exact comments were, "She is a broke-ass bitch," is what he told her here in the court. So the complete disregard for the court system, the court's orders, to me suggests that this defendant's 771.1 status should be revoked immediately. And I think that the defendant's displaying this clear disregard for the court and Your Honor's orders. Your Honor, I think what's most appropriate is the consideration of a revocation of bond. I'll defer to your discretion. I trust your judgment, but that is something that I want to bring to your attention.
I don't have an independent memory from March 17th, and I'm going to ask you if you do. Was the restitution, part of a settlement discussion between defense and prosecution?
So, Judge, I am relying on the register of actions as well as what was brought to my attention. I was not a part of this actual plea. It was my colleague who accepted it.
Okay.
However, the plea form does indicate that people are seeking restitution. And if I recall correctly, on that specific day, I remember having a conversation with the victim, and she advised me that it was to be ordered within 60 days. And I confirmed that by checking.
It absolutely was ordered within 60 days. My handwritten notes say that. The register of action says it was actually a discussion about how it was going to be paid. It was going to be with Zelle through the victim's father. So there had to be a fair amount of conversation about it on the 17th.
Yes.
Okay. Okay, anything else from the people at this point?
So we are here to move forward with taking testimony if it's necessary. The complaining witness is here. She would testify, as an offer of proof, she would testify to not being in receipt of any monetary damages, as well as the statements made by the defendant at the last court hearing. The court officer that observed part of the incident, I don't know if he knows exactly what was said, but he responded based off of his observation. He's present if necessary, so the people are prepared to move forward if necessary.
Okay, well, just so we're clear, one of the conditions of the delayed sentence was the restitution, but there was no order of no contact. So he might, not on the 17th, he may have violated a PPO, but I don't enforce PPOs.
I understand.
So today's issue is he was ordered to pay $1,000. It sounds like it hasn't been paid. So,
And, if it's easy, I did talk to Mr. Johnson, and I was not obviously,
yeah,
so I didn't see the actual order, said within 60 days. He didn't recall that. The bottom line is that he hasn't paid in court. He's made about $250 to $300 worth of payments in the fines.
he wasn't supposed to pay us restitution.
Well, I don't believe it was $500.
That's not what we're here for. The court costs are $500. We're here because of the restitution order.
I think there was a misunderstanding that he thought he could start paying the restitution when he finished paying the court.
Don't know. If he gave you that impression, then he's lying to you, because we distinctly said he would pay restitution through Zelle. This court doesn't take payments through Zelle. So he walked out of my courtroom knowing he was paying $1,000 through Zelle for restitution, and he owed us $500 for court costs.
I believe that one of the conditions, Your Honor, according to my, again, on information only, that one of the requirements was that he was supposed to get action, a list of what he was supposed to have taken that equals the $1,000. That list never came forward.
That was never part of my court order.
Judge, I believe that this is really a misunderstanding, and it wasn't deliberately not wanting to pay. He understands that he pled to this charge, and that went over the court order as a result of that plea agreement, that he is definitely committed to getting it done. I believe that he didn't make any comments to me that he didn't intend to pay any restitution. He basically said that he thought that he could start paying the restitution when the court was taken was complete, and then we pay that restitution correctly to the complainant.
Then he came up with that all out of whole cloth, because he didn't get that from anything I told him. So how soon can you come up with $1,000 restitution, Mr. Johnson?
I'll say probably by the end of the year, but I did want to file that motion.
No, I'm not giving you the end of the year.
But I was trying to file a motion because the thing is.
Okay, what stopped you from filing the motion?
Stop me?
Yeah.
I thought that's what this hearing was about.
No, you just said you wanted to file a motion. I said, what stopped you from filing the motion?
That this court gave, I'm not familiar with the terminology as far.
Okay, no, back up. You just said you wanted to file a motion. And I asked you, why didn't you file the motion? What stopped you from filing the motion you want to file?
This court gave.
Okay.
I'm supposed to be filing the motion.
Okay. All right, anything else before I deal with the violation of probation? Well, hold on, it's not a violation of probation, it's a violation of the terms of the delayed sentence. So terminology is clear.
Yes, and to that point, Your Honor, we would ask the court to maintain his deferred jurisdiction.
Absolutely not. What I'm getting out of this attitude I'm getting confirms everything I just heard from the prosecutor. So the conviction will enter, and you'll pay the $1,000 restitution within 30 days, or you'll do 30 days in jail. And you still owe the court money. And just for the record, he's had since March 17th to pay that restitution, and so far he's paid zero. Good day, gentlemen.
Your Honor, there's just one thing, if I may. Is it possible to add a no contact order between the defendant and the victim?
On top of the PPO that she's got from circuit court?
Just because I don't know too much about what's in the PPO and how long that's going to last, I just want to ensure that I'm doing what I can on our case. If that's okay, if not, I understand.
Your Honor, other than what counsel said regarding what was said at court, there's no contact between my client and the complainant in any way, shape, or form. No postings on social media, no contacting through friends, no direct contact, no text messages, no voicemails, nothing.
And that is correct, Judge. There's been no information brought to my attention that would suggest otherwise.
Understood. Well, is there any reason to have contact with her?
No.
Then I'll order no contact, because I'm going to lose jurisdiction on this case in 30 days. Because either the restitution will be paid and I'm done with the file, because I've already terminated the delayed sentence, the conviction is entering, or he'll be going off to do his jail time, and either way, I'm done with the case. So I will say no contact for 30 days. Understand, ma'am? All right, any questions?